At the Board Governance and Legislative Updates Workshop held on June 16, 2016, Ken Chadwick of Chadwick, Washington, Moriarty, Elmore, and Bunn provided attendees updates on the revisions of certain bills passed by the House and Senate.
After considering 3,200 bills, how many of those bills were actually read? No one is really sure, but they had 3,200 bills that they worked on, or at least they said they did. Approximately 1,800 of those bills actually passed, and the new laws, as I said earlier, will go into effect as of July 1st of this year. This year was one where the legislature took away that which they had given last year, especially as it relates to rental of units. Last year, the code was revised to give associations a little bit more authority over rental units. This year, many of those rights were taken away. The general theme, if we're going to use Cliff Notes tonight, the Cliff Notes would say something to this effect. If it's not in your recorded documents, you're not going to have the authority to do something which would otherwise make reasonable sense, but there is no such thing as implied authority anymore. The courts have kind of indicated that with a couple of the decisions that they've come down recently, and now the legislature is doing the same thing. So what they've said both in the Condo Act and the POA Act is that except as it's expressly authorized in those documents, the association cannot charge a rental fee, application fee, or processing fee in excess of $50 when it comes to rental of units or anything that has to do with leasing or rental of units. One of the things you need to recollect too is that in both acts there's a provision that says that an association, whether it's a condominium association or a POA, cannot charge any fee unless it's where?
In your bylaws.
In the recorded documents. In the recorded documents. So now this theme is continuing. You cannot, unless it's in your documents, require an owner to use a lease or lease addendum prepared by the association. They've added lease addendum this year, but realized that, and that was because in part associations were attempting to do via lease addendum what they used to do with leases. Last year they restricted the lease, now it's a lease addendum. They're catching on quickly down in Richmond.
A real burning question, because I heard somebody say something. Recorded documents, are they bylaws as well, or just your deed and corporation documents?
I'll give you the legal answer.
It depends.
Ooh, very good. Over there in the corner, it depends. If it's a POA, the only recorded document that is required is the declaration of covenants, conditions, and restrictions. Reston, in terms of cluster association, there's a great variety in terms of what documents exist for any particular association. If you're lucky enough, you might have a declaration, or you might have a deed and plats, a deed of subdivision and plats, that would give you some control, potentially. But you got to look there. Not in the articles, not in the bylaw. Because those are not recorded documents. They can be, but they're not considered for a POA a recorded document. There's a line of cases that comes out of Central Virginia. It's a lake community. The Arrowwood line of cases where an association attempted to get a lot of different authorities, and they started with trying to get the declaration amendment. They couldn't get the requisite vote, so what they did was they adopted new bylaws which had a lesser percentage requirement for approving the amendments, and then recorded the bylaws. And the court said, no, you can't do that, because bylaws by their very nature are generally not recorded, especially in a corporation setting. So the bylaws were not effective. What you have to do is amend the actual recorded document which established your association. Condominiums are different. So how many, just out of curiosity, any condos in the audience tonight? Ooh, none. So we'll just stick with the cluster side. Clusters It's got to be in the recorded, if it's a deed of subdivision, if it's on your plats and plans, if it's in your declaration of covenants, conditions, and restrictions, those are going to be what can be considered recorded documents. So be aware of that and realize that articles and bylaws are not going to be effective to get you where you want to go if you're trying to do something that is a requirement to be in the recorded documents. Can't charge any unless it's in your documents. Once again, your recorded documents. You can't charge an owner or a tenant any deposit requirement. There are some documents out there, actual recorded documents, that allow the association to evict a tenant of an owner in the event they violate the rules and regulations. Legislature decided they're going to take that away and prevent that from happening unless, once again, it's where? In your recorded documents. So we go on, and there's still issues with regard to rental of units and lots. And where we find a lot of interesting cases with amendments to documents oftentimes are either in resort areas or the lake communities where there's a lot of transient use of homes. And some of the members who bought there as second homes don't like the fact that they've got people who are renting their homes on a weekly basis and there's new people coming in all the time. What else is on the horizon for community associations? Hear of anything called the Airbnb? And if you noticed recently, there was an article that came out either in Forbes or one of the other business magazines saying that Airbnb is no longer going to be focusing on the resort residential use kind of concept. They're going to be going after commercial accounts now. And the businesses renting in homes for the purposes of having long-term or longer-term business engagements with their companies so that they can have people coming in and out of a town or a locality renting individual rooms or basement apartments or whatever the like is. So realize you're going to see more and more of that. Once again, if you're interested in doing something about it, you've got to amend those recorded documents. So we get into a situation once again with regard to, this is actually one of the things with regard to contact information. One of the reasons many associations wanted leases or copies of leases was to get information about who was actually residing in the units. Oftentimes, if it were an emergency or something like that, now there's explicit authority that the association can obtain contact information for the owner's agent, rental agent. And there's also additional information with regard to contact information for the tenants as well.
Excuse me.
Yeah, sure.
Is there anything about background checks so they don't rent it to a felon like it happened in our...
No, but that's an interesting concept because we'll get to another piece of legislation this year having to do with sex offenders.
Okay.
But we'll get to that in a minute. Association must recognize the owner's written designation of a licensed real estate broker. So realize that if an owner, out-of-state owner, comes to you and says, this is the guy who's in charge of my rental, I want you to deal with them, you've got to recognize and you've got to deal with them for the most part when it comes to dealing with the tenant or anything going on at the property. So now you've got that responsibility. Question?
So, can you go back one slide?
No, I can't. I refuse to.
Authority to obtain contact information for authorized occupants.
We need
of tenant vehicles. So, we are able to do this now without bylaw.
Come July 1st,
July 1st.
you will be able to get that information from...
And what happens, what is our recourse if they do not want to give that information?
Everybody hear the question?
No.
The question is, what happens if the owner of the property doesn't want to give freely or voluntarily the information that they're required to give? And what's the answer?
Nothing.
What's the only way that you really ultimately ever enforce restrictive covenants?
Somebody wants to turn it.
Somebody said it over here. Sue them. Sue them. It's called injunctive relief, whether it's mandatory injunctive relief. But you have to go after them and you have to make your point. That's, and obviously that's easier said than done, especially when you guys are charging all you're charging for your assessments on an annual basis. Where are you going to get the kind of money that you need to pay an attorney to enforce something? But if it's important enough, you will. And at some point, you're going to have to draw the line and make that determination. And we'll get to that in a little bit later when we talk about the Reston Association and clusters.
So what is considered contact information and vehicle information? Do you have to get the phone number or email, or what do they consider contact?
At this point, it's unspecified, but generally speaking, it's going to be the information that you've just said. So in terms of the tenant's name, other occupants in the leased premises, with regard to vehicles, what kind of vehicle, maybe license numbers, that kind of stuff.
Make and model or whatever.
Yes.
Okay, and then, sorry, last question.
Remember, she said last question.
Pertain to this particular vote. But does this also pertain to homeowners? Like, can we ask a homeowner to provide the number
No.
of people who are actually living there?
No. Now, you should have that information and can acquire that information through the county in terms of who owns the property.
But how many people are living there?
That's not something that you're generally going to get.
Can you ask people who own the property to be providing the vehicle information?
No. No, just the tenants at this point. Okay, thanks. Guess what they changed this year again for the umpteenth time? Issues regarding resale certificates, or disclosure packets in the case of the POAs. Timing of update fees. Last year, they put a 90-day moratorium on charging an extra fee for updated disclosure packets. As you are or should be aware, there's a disclosure packet. If the purchaser or the seller requests an update to it because some time has gone by, you are able to give them an updated, but generally speaking, there's a charge that goes along with that. Last year they said no, not within 90 days. If they request one on day 89 after you've given the packet, you cannot charge them an update fee. But if it's 92 days, you can. The 90-day period has been taken away, and so you now don't have to wait to charge an update fee if somebody's requesting an update packet. For condos and professionally managed POAs, the deadline for paying the resale certificate fees has been up to 60 days. It used to be 90 days, they moved it down to 45 days, and now it's 60 days. So realize, you feel like a yo-yo, you ought to, because that's exactly what's happening. So, and when can you charge that fee and get that fee? Before or at the time that you give that document to the seller? When do you have to wait till? It's a settlement, generally speaking, unless settlement does not occur 60 days after giving the packet. So realize that, and unless you're Reston Association, which has it expressly in your documents, then you don't have to wait. Resale certificates. Once again, there's the advantage of either giving a hard copy version of the disclosure packet, or in many cases, many associations can deliver an electronic copy. If you're delivering it electronically, the seller now has the ability to designate up to 5 people to receive that disclosure packet electronically. And it can be just about anybody who is designated by the requester of the packet. So realize that has changed now. There is similar language in the Condo Act. Condemnation of common areas. This is actually a benefit to associations. Heretofore, an appraiser, after notice is given to the association that either a locality or a public utility or some other agency that can condemn property, take it by eminent domain, would come in and an appraiser would say, well, the common area property that is being delivered over to the company or the entity that's doing the condemnation has no value. Why would that be? Because one, it's common area, and who is taxed for common areas? The association's not. And if you are, you need to check with your legal counsel and or your accountant, because common area property is not taxed. Alternatively, what was happening was they were saying, well, the association doesn't pay any taxes. So, and it is in fact put into the valuation, the common area taxation that would otherwise be there is put into the valuation of the individual lots within the community. So the reality is that since there was no tax value, there was no appraised value, so it was a nominal fee that they would get during condemnation. Now, the legislature has changed this, and it must be appraised, whatever the amount of property is. And usually you find this where roads are being widened and strips of land are being taken. It has to be appraised at the highest and best use, which means you're going to be getting residential value if you're zoned residential for those parts of your property that are being taken through eminent domain. Corporate procedures, the Non-Stocked Act. How many of you are aware or know if your documents have a provision called action without a meeting? Okay, what is that? What is action without a meeting?
You can do something over email if it's a unanimous agreement.
It's taking a decision, taking an action, making a decision by unanimous consent of all the board members, not of a fraction, not of only those that respond, but at this point of all the board members. And that power and authority comes up oftentimes under the Virginia Non-Stock Corporation Act, where there is a specific provision to that effect, and which all clusters associations within Reston Association are supposed to be incorporated. We'll get to that a little bit later too. But the reality is here, the legislators actually got a proposal from one constituent in a district that indicated that they were frustrated by having to get all the board members to sign off. Why would you have such a high threshold to begin with, especially if you're a community association in the Commonwealth of Virginia?
Sunshine.
Right, exactly. The answer was a sunshine law, or the public meeting requirement of the acts, both the Condo and the POA Act. So what you want is to have everybody in a room meeting, as many of the board members as possible, and talking about what decisions that are being made and what kinds of actions they're going to take, because that fulfills the public meeting requirement. But oftentimes, in emergency situations, there is a real need for action without a meeting, because your next board meeting is not for another 3 weeks, and nobody's going to be around for a special board meeting. So you get action by getting all the board members to consent to the action being taken. So this constituent said, well, what about making just a simple majority? And there was a lot of give and take, and there were a number of different proposals. What happened, which is a good outcome, because nobody will ever get it in the Articles of Incorporation, because it takes too much in terms of vote to get, it's a supermajority vote to get Articles of Amendment to your Articles of Incorporation. But the legislature now has deemed that if you can get your Articles of Incorporation amended, you can have a simple majority take action without a meeting of the board. We don't recommend it, and it's against the public policy, we would argue, because once again, you're supposed to be having public meetings for the purposes of dealing with these issues. So realize that if you can get your Articles of Amendment, you can reduce the written consent requirement to majority of the directors. But with respect to right now, unless you get those Articles of Incorporation amended, you still have to go with unanimous consent of all board members on the issue that is presented.
But we have that authority, we're saying right now. I mean,
I
thought we had to, everything we did, regardless of the vote of the board, had to be public open meeting.
If you're incorporated, there is that authority. There is a Virginia Non-Stock Corporation provision that allows for that.
I think there are certain things that we're authorized to do in executive session related to contracts and stuff.
That's different.
And so I think in that situation, we can handle things by assuming we comply with this without that needing to be public.
Right, but.
It's got to be at a meeting. Because you've got to go into a meeting to begin with in open session, and then go into executive session for the purposes of one of those statutory requirements. You said that was your last question. Gee.
So I just want to give a real example that could happen to any of us. So let's just say like a tree falls blocking a drive area.
Is it in Brooklyn?
It's in Reston.
Sorry.
And
Sorry.
so obviously you need to have some sort of decision about who's going to remove the tree. So if one person is on vacation without access to email, text, whatever, the people who are there, who are able to make the decision, can that be done over email, or does it have to be a special meeting because the extra person is not?
Trees present an interesting...
Okay, then pick me a...
No, I mean, a tree is great because it shows both sides of the issue. Where's the tree? Where is the tree located? Is it on common property or is it on a lot?
Property is blocking a driving area. It has to be taken care of.
So it's blocking
The exit.
an exit, which is common area as well. Is that what you're saying?
Yes.
Then it's going to be, in essence, the association taking care of that tree. And oftentimes, under those types of situations, usually there is parameters that a president of an association might have to get something like done on his own authority. And if there's a problem, bring it back to the rest of the board at the board meeting to ratify the decision of the president, having done that. It's within the scope, it may be within the scope of his authority. It may be something that has obviously happened from between the last meeting and the current meeting. And generally, the officers are there for that purpose, to deal with some things that arise. Now, if it's a large dollar amount, if I'm the president, I know I got to get that entranceway clear to that tree. But if they come back and say, because there are many entranceways that are closed because a sudden burst of wind came through and closed off a number of clusters, they come back, it's going to cost me $5,000 to do. I'm going to go to my board first and make sure that I've got at least the majority of the board on my side to go forward.
But I guess the question is, can that be done through email, or does it have to be a special meeting?
Technically, it should be a special meeting of the board. Realistically and practically, I think you need to weigh the value of trying to call a special meeting, what your notice requirements are. You know, there are notice requirements for special meetings as well, usually 3 to 5 days, depending upon what your documents say. So even then, you're in a situation where you're going to have to wait, and that's a situation that your friends and neighbors and fellow community members are not going to want to wait for. So I think a lot of times the board and the officers need to work towards fulfilling the obligations that they have as the board and as officers to deal with those situations. And I think the president probably would have the authority under those circumstances. Oh, sorry. We're not taking questions from the back, sorry.
You always do that to me. We do things by email, but then when we get to our meeting, then we reaffirm it and approve it again. So basically, if we need to get something done, we'll get, everybody agrees. And then when we get to our meeting, we ratify it again.
All right, here's the problem with that, because it comes up right in your question. We do a lot of things by doing what you just said. And that's totally contrary to the public policy of the open meeting and public portion of the meeting. You should not, and that's what the legislature is afraid of, that you all are going to go into hiding, do everything by email, get the consents, or even not get full consents, and then come to the meeting and rubber stamp decisions. That's not what the public requirement for a public meeting is there for. And in fact, if you look at the statute literally says the association cannot use work sessions or other types of meetings to avoid this rule. Once again.
Then how do you get a person in the cluster to come to a meeting? We have none.
Well, you don't need to get a member to come.
No, I mean,
you just have to be open to it.
We're open to it.
All right. So let your members know that you're open to it, and if they're interested, they'll come. You don't need a member there to conduct the meeting. In fact, I would argue, why are you afraid of having a public meeting if nobody comes?
Oh, no. It's
just a thought.
I'm sorry. Your thought expressed that, that people needed to know.
Well, it's the intent of the statute. The intent of the statute is to have people have the availability of people coming to those meetings, because what was happening, and I'll give you the example that led to the legislation to begin with. It seems that a lot of stuff comes out of the lake area communities, which is down in the central part of the state and further west. But what was happening is the board of directors, validly elected, would get together and meet the second Saturday of every month, and they would call it a work session, and they would close that meeting to anybody other than board members and management. Fourth Saturday of every month, they'd meet for the board meeting, and you'd have an agenda, and you would have the board sitting up front of the room, and they would say, motion 1, second, vote. Motion 2, second, vote. Motion 3, second, vote. There was no discussion. There was no indication of anything getting done at that meeting other than what? What had been done previously at the work session that was closed. So that's why you now have the public meeting requirements in community associations, because legislators heard about that about 10 years ago and they put it in. So if you want to continue down that path and have more restrictions, then make all your decisions by action without a meeting, because the legislators will pick up on that and they'll do away with that requirement.
We have
or that ability.
People that just work crazy hours, myself included, and we're looking at the option of using something like GoToMeeting, webcams, things like that, where physically you can't be at the meeting place, but you still want to participate. And we haven't made decisions yet, but it looks like it might give people an opportunity to find out what's going on.
So what are the limitations there, or what are the requirements of having a meeting like that?
Oh, I just read it.
Go ahead.
At least 2 of the board members have to be in the meeting.
Have to be physically present where the members can come to for the purposes of having the meeting. And any other members who are on the phone, it's perfectly allowable for them to vote by phone and participate in the meeting.
What about making access to that virtual meeting to anyone?
You could do that as well. But it's still, the requirement, at least at this point, is you got to have 2 physically present, 2 board members physically present.
Everyone has to be here.
All right. I know I've whetted your appetite now with this automatic notification of sex offender registration.
What if it's not a sex offender?
Well, that's not the population that I'm dealing with right now. I'm dealing with people who are and are listed on the state police website, okay? And what you need to be aware of is that now, with the new laws effective July 1st, associations can submit a request to the state police to get notice of any sex offender listed or newly listed that's within their zip code, and get an automatic notification. How many community associations in this room want to do that?
I do.
Okay. Are you willing to accept the responsibility and the liability of undertaking an affirmative obligation once your members of your community know that you're doing this and monitoring it for them? Are you willing to take on that liability when you miss one? Are you willing to take on the liability when something happens with a newly registered sex offender in your community that you got notice of and now there's been an issue? The answer is you won't, and you should, and your liability insurance will go through the roof, and you may have trouble getting liability insurance. So leave this one alone. There is no affirmative obligation on the part of a community association at this time, unless your recorded documents say otherwise, and I don't think they do, to do this. And there's no reason for a community association to do this. The best thing is to alert your members to the state police website so they can then make the determination as to whether there's anybody in their neighborhood or within the zip code for purposes of sex offender registration. The other thing here is that with regard to the website, do you think the state police have a lawyer? If you do, then you're right, because you should read the disclaimer on their website. And you should also read what they say in terms of any misuse of this information leads to a criminal charge as well. So I understand and why people would be interested in this, but a community association should not be. Refer your members to the state police website, let them do the legwork, let them do the heavy lifting, but don't get into acceptance of an affirmative obligation, which then becomes the association's and then becomes the association's potential liability as well.
Just out of curiosity, is that notice something that in fact is required, not by the association, but we just need that out?
Yes, yes. And can you imagine if you got it wrong?
Oh yeah, no,
And the name of the person that was on that sign was not the same one that was listed on the...
I didn't know there was something at the state.
No, there is no requirement. I will tell you that we have had associations, and once again, it's in the resort and lake communities, who have requested, and actually it was a developer who requested that we put in a provision saying that property would not be sold to sex offenders, or sex offenders would not be able to reside or occupy homes in this community. Very difficult to enforce. There's no real legal basis for it, but they wanted such a provision. I think best left alone, best left members to deal with this issue on their own. Let them go to the website, find that information out. Localities. You've got kind of a bifurcated system. You've got two scopes of authority in the local jurisdiction and a community association with its private covenants. So when somebody has to go for a permit or a license, they go to the county, they get their permit or license. Let's say it's for a home occupation, in-house home occupation license. Does that mean that an association then is preempted by the locality to enforce its covenant that says no home, lot, whatever improvement can be used for any commercial purpose? No, it's not. What was happening, at least in Arlington County, was that Arlington County was very proactive, and it's Arlington County and one other jurisdiction, proactive in making sure that there was a connection between the locality and community associations, trying to help community associations out. The legislature got wind of that, and they said, no, we are going to separate the two of you, because we want you guys to make your decisions independently, and we want community associations to make their decisions independently. You cannot make your approval for that license or permit contingent upon the association giving its approval first. So what happened was they're separated now. The localities are barred from seeking from the individual requesting the license or permit any information that relates to whether they've gotten the approval from the community association first. So no longer shall there be working together between locality and community association when it comes to permits. Service of process on registered agents. This is going to be very important for most of you. I would assume that many of you in this room have a board member or officer serving as the registered agent for your community association. How many? Raise your hands if you do that. Okay, a number of you. Be aware that today you're okay, but come July 1st, what's going to happen is if the registered office of the corporation is a private dwelling, your home, which for the most cases it is, then the sheriff private processor come July 1st can serve anyone at the home 16 years or older, or post a copy to the door for purposes of service of process. How does that differ? How does that differ from a regular registered agent?
Got to serve in person.
Say it again.
Serve them in person.
You've got to serve the registered agent in person. In every other situation, and up until July 1st, that's still the case. Come July 1st, the law changes, and if it's a single-family home or other private home, townhome, whatever, that is the address to serve the registered agent. Now it can be not the registered agent. You can serve a member of the family over 16, or by posting it to the door. Now, who would have suggested something like this? What madman might suggest something like this? How about somebody who's made it a cottage industry to sue community associations on behalf of individual owners? Because now it's a heck of a lot easier for him to get service of process over community associations, and that's exactly what happened. So realize that your legislature is not there necessarily to serve you. All right, that's pretty much the legislation. It really wasn't a bad year. It was actually kind of a good year in terms of legislation. But overall, what we're seeing is if you're going to have the authority, especially as it relates to restrictions and or assessments, it's got to be in the recorded documents. Alternatively, what we're seeing is 1 year they give, the other they take away. So we're anticipating some of that. There was a bill we didn't discuss tonight that has been carried over. It's going into the Housing Study Commission to be reviewed between now and December of next year that deals with Airbnb. There was a piece of legislation having to do with localities, how they were going to treat them, how they were going to tax them. Fortunately, the hotel industry got on board with the community association industry. And actually, before it actually went to the Housing Committee, Virginia Legislative Action Committee for CAI was able to put language in saying that regardless of the circumstances of this bill, it would not prevent any community association from enforcing its covenants if there were restrictions having to do with periodic short-term rentals within their community. But hotel industry came along and said, no, we want it put over to Housing Study Commission, that's where it is. Realized that it's a big business, there's a lot of money to be made in it, and if we're not careful, they're going to get their way because they're paying a lot in terms of lobbyists.
Reston is full of Airbnb rentals. What is RA doing about that?
RA doesn't have anything in its documents that would allow for us to do anything because there's nothing about leasing per se. So that's one of the issues. Reston and clusters. What is a cluster? And that question kind of goes along with the concept of what documents you may or may not have. Because when it was set up, it was not as clear as it could have been, and the methodology for drafting these types of documents were not as clear. And there was stuff in the Reston Homeowner Association documents that kind of said, well, here's what a cluster is, and these are the powers that it can have. And there still is to this day. However, in this day and age, what would have happened if we were drafting them today, one of two things would have happened. One, there would have been Master Association Reston and Sub-Association clusters. And that each cluster would have had their own recorded declaration of covenants, conditions, and restrictions, regardless. It didn't happen back in the 60s and the 70s. The other way that it would have been done is said, no. What we're going to do now is have Reston Association, and then these are neighborhoods that are still subject to all of the Reston covenants, but they may have separate declarations and they may have separate requirements for each of the neighborhoods dependent upon the nature of the neighborhood. It may have something to do specifically with architectural style, it may have something to do with housing type, it could be a lot of different things. But realize today we would not, and hindsight is always better than foresight, but we would not be in the situation we are today. In Reston's case, Reston Association does have a defined cluster, 2 or more lots designated as a cluster on a recorded subdivision plat of the property. Property is capitalized there because property means anything that's under Reston. One thing that you need to remember is that Reston's documents, as amended, come first. They were there before anything else was, and they were there before your properties were developed. So they're there, they're on the property, and they subject your property to their terms and conditions. Reston Association clusters are subject to Reston deed. They're defined, and it's a non-stock membership corporation. What does that mean?
issue.
Sorry?
No stock issues.
There's no stock issues. That's great. What it means is you better go home today and make sure that you all are, in fact, registered corporations with the State Corporation Commission. Because if you're not, the potential exists that you're either expired as a corporation or terminated as a corporation. And what happens when a community association of individual members or the corporate status either expires or terminates?
You're personally liable.
All the individuals within your cluster are potentially, individually, jointly and severally liable for any amounts that is owed by the now defunct corporate entity. So if I'm Bill Gates and I'm living within a cluster, do I want any creditor coming after me because I'm deep pockets, because my board of directors let it lapse? And unfortunately, what we're seeing more and more is that corporate status is being let go too quickly and too radically because the registered agents aren't giving the information to the boards of directors. Every year you get something from the State Corporation Commission. Every year you have to file an annual report. That's why they call it annual. And so every year you need to make sure that you're getting something from whoever your registered agent is, because it comes to the registered agent, and that you are filing it and paying the fees associated with that annual report. That is a prerequisite for being a cluster.
Can you define registered agent first?
Registered agent is the individual that's appointed to receive service of process from the courts for any action that's taken against the corporate entity. That's the registered agent.
It's not on the board?
Generally speaking, no, well, it can be if it's an attorney.
Yeah.
If it's an attorney, it can be. A licensed attorney in the Commonwealth of Virginia. It can be a corporation that is licensed to be and serve as a registered agent. But most of the time, in many community associations, it's usually a board, it has to be a board member or officer otherwise. Okay.
How do you know who it is? How do I know who it is?
Call SCC.
I'm going to ask for a serious moment here. Let us pray for this. The reality is you can go to the State Corporation Commission website, and you can find out who at least they have as the last registered agent of record. But sometimes that person has gone and moved on,
Right.
and there could be that your corporate entity has either expired or terminated as a result, because they may still be a registered agent, but they're not forwarding any documentation to the current board. So that's why it's very important to know who your registered agent is and to keep up with them in terms of that. A real interesting question is raised with that second bullet there, owner of each lot within, I'm sorry, must be a non-stock, the first bullet, non-stock membership corporation. What happens if your corporate entity is expired or terminated? Does that make you a decluster? Are you declustered as a result of that? It says in Reston Association documents that in order to be a cluster, it's got to be a non-stock membership corporation. It's an interesting question. You're still subject to the covenants, but you may not be a cluster any longer, and you don't want to be there.
So I'm hoping like help. I mean, in this instance, that it is possible for a cluster to use a professional management company to have that as a designated
I would check with your legal counsel on that, because in essence, it's supposed to be an attorney licensed and authorized to practice law in the Commonwealth of Virginia, an officer or board member, and then there are provisions for a certified registered agent company that serves as registered across the company. So you need to be careful, and there are limited number of people who can serve as registered agent.
I think that's the case.
Okay. Did I answer your question?
Yeah.
Okay. So here are the different things over 35 years of my experience in working with clusters, condominiums, and or Reston Association. Here are some things that we found in terms of different clusters. And there are all sorts of variations on a theme. There are some clusters that are alike, but there are more that are unalike, dependent upon what their documents are. So one of the things that you'll find, obviously Reston's deed was filed first, subjects all of the property within the context of the greater Reston community to the provisions of the Reston deed. Then we get down to the next level. You can have deeds of dedication and subdivision. These would have been things that the county would have required to be recorded and signed off on by the county that set you up and show you the property as a whole and show you how it was subdivided into individual lots and common area. Plats. Those are oftentimes more critical than anybody ever realizes, because oftentimes on plats there are things, and don't be shocked by this, but there are things that are known as plat notes that are put on there by the original architect and developer, which actually serve and can serve as restrictions to the properties involved. So there may be things in the plats that you've never seen or never realized were there, but they are there for the purposes of a recorded documents, and the plats do count as recorded documents. They govern all of the property under which that plat was submitted, or over which that plat was submitted. So, deeds of dedication and subdivision, plats. Separate declaration of covenants, conditions, and restrictions. There are a few of those. I'm sorry, hand up.
Give an example of some notes that are on a plat that are restrictive.
I'll give you one that I was involved in down in Woodbridge area. There was a and this goes back many, many years. Anybody here remember the RTC?
Resolution Trust.
Resolution Trust Corporation, where all the savings and loans went under. The RTC was appointed by the federal government to take all of these underwater savings and loans and their assets, and they took them over and tried to mitigate all of the losses that were being handed out by the market and by stupidity of mortgage lenders and stuff. Do I have any mortgage lenders in the room? In that situation, there was a plat note. Entranceway, and actually going back to our tree issue, and I wish I had a bulletin board or something, or a chalkboard to show you this. There were two sides to the entrance to the community. Both sides had never been properly conveyed to the association in question. And they were like 3-acre parcels each. Okay? So in doing our research, we got the plats, and on the plats, Gott sei Dank, which is a German term meaning God be thanked, there was a plat note. Now, the plat notes were different for each side. And the plat note on the one said, this property to be conveyed to the community association. On the other, it was more nebulous. The RTC brought suit against the association because we were challenging their ownership of that property and what they could do with it. And the Prince William Circuit Court agreed with us and said because of the plat note, the developer on the one side could not do anything but convey that property to us. On the other side, we negotiated a settlement because he saw the writing on the wall, because there was still enough there to say that there was a questionable issue. And what we did on the other side, we gave in to some easements and we got the property underneath. So plat notes are important. And so that's what I meant when I said a plat. It can be a restriction. It can be all of the roadways are to be private, or all the roadways are to be in the hands of the association as far as rules and regulations, whether they're private or public. All sorts of different notes can be put in there. And it's usually done by the developer and their surveyor, or engineer rather, who put the plats together, and it usually relates to how the property is to be used. So be aware that that is a possible source of additional authority or power within an association. Separate declaration of covenants conditions is like Reston association documents being recorded twice. There could be a separate set of documents. Be careful here once again, because those documents could have been an exhibit, could have been an attachment to that first document, the deed of dedication and subdivision. And Exhibit A, I've seen it where they're not separate, they're part of the deed of dedication, and it says, Exhibit A, declaration of covenants, conditions, and restrictions applicable to this community.
They're not required, are they? The CCRs, they're not required, are they?
No. Well, that's a loaded question.
Yeah, I know.
Back in the day, they were not. Most of the time now they are, and when it's county approved property, most of them want to see them, and at least be aware that they've been recorded at some point. There are some jurisdictions in the Commonwealth of Virginia that actually want to review the CC&Rs, the Declaration of Covenants, Conditions, and Restrictions, before they're recorded. So it just depends upon the level of sophistication in the county, the level of detail that the county wants to see before anybody does stuff with the property within their jurisdiction.
Our cluster doesn't have them.
I won't say most. Many clusters do not.
Okay.
Many clusters do not, and it's a problem and a shame, both of those.
If you went back to the corporation documents, you said there's a high hurdle there, financial or otherwise. Could those be established?
The answer to your question is yes, they could be, but they would only subject those properties who consented to being subjected to those covenants. Right. So in other words, we have, let's say a 10-acre, we have a 10-member association. If you can get all 10 members to agree to it and submit all their properties from henceforth in perpetuity to a set of declaration of covenants, conditions, and restrictions, absolutely. But all it takes is one who doesn't want to be part of it, and it's going to defeat that purpose.
Right. Okay.
But in that case, it would be 100% of all the lots within the association to establish a new, never before seen declaration of covenants, conditions, and restrictions.
Is it something that gets filed, that would be filed with the county?
Mm-hmm. It's of record.
That's where we would find it if we had it.
Correct. Correct. So you've got your separate declaration of covenants, conditions, and restrictions. You also, in terms of documents, have articles of incorporation and bylaws. What are they? Articles of incorporation are a document that simply sets you up and establishes and creates you as a non-stock corporation under the laws of the Commonwealth of Virginia. Bylaws simply add meat, generally are not reviewed or asked for by the state. It's a corporate document. We've been in situations where associations have been very confused because they've got 3 sets of bylaws and they don't know which ones apply. Because over time, somebody decided they were going to change them, whether they got the proper vote or not, and so they're stuck in with the community association's documents. That literally happened. We took over a new property. We said, we'd like to see we'll get the recorded stuff, give us your articles and bylaws so that we know what's going on. They came to us and said, here are our bylaws, and they have 3 different sets. All different dates in terms of when they were amended or affected, but there was no clear indication of which one was proper or not.
So what happens in that situation? Because I think we're in that.
What happens is you have to see what authority the articles give and the bylaws have, and maybe the board has the authority. Let's say there are 3 sets of bylaws, and all those sets of bylaws say the board has the ability to adopt a set of bylaws. In that case, we may be able to get the board just to adopt a new set and establish a baseline right there. It all depends upon what those documents say.
Okay, and then I think you might be getting to it, but can you also go through the difference of what the bylaws and then like the rules and guidelines and regulations are?
I wasn't going to get into the rules and regulations, but I will for you tonight. It's your special night. The bylaws, those are the things that add flesh to the bones. Articles are simply establish you in the Commonwealth as a corporate entity. The bylaws generally deal with things like annual and special meetings of the members, annual and special or periodic board meetings and special meetings of the boards, things that are more or less stuff that is administrative in nature to give the association, its members, and the board members some guidance as to how to do things and what expectations the members can have, what kind of expectation the board members who serve have. What are members for?
Dues.
He's right. Dues, maybe raising dues sometimes in your documents, amending documents. Generally speaking, members' rights are very limited in nature in terms of the organization. Most of the organization's power and authority is going to be vested in the board of directors, and there's a reason for that. It's a corporate model. And so as a result, the board is going to have most of the authority to do things on behalf of the association from one annual meeting to the next. So the members have limited authority. Boards generally have more authority and do things based upon their scope of authority set into the documents. Now, one of the things that you will oftentimes see in one document or another is the authority of the association acting through its board to establish rules and regulations. Can a rule or regulation differ from anything that's in the recorded documents, articles, or bylaws? No. You can never have, because there's a hierarchy of documentation. Recorded first, articles, bylaws, and then board-adopted rules and regulations. The resolutions and rules and regulations are lesser because it's not the members that adopt them, it's the board that adopts them. And if they're not recorded, I mean, you could go down to land records and record them for a fee, but they wouldn't have any more authority than what they were unrecorded. So realize that in terms of that, your rules and regulations are lesser because it is less of the members voting for that.
But when you say can they be different, do you mean they can't be in contrast with each other?
They can't contradict one another. Okay. So let's say the documents have, you cannot, well, here's one that's actually in an association that's seeking to amend their documents now. In the recorded bylaws, it's a condominium association, so in a condominium, both the declaration and the bylaws are recorded. That's a statutory requirement. When you think condos, you need to remember that condos by very nature cannot exist without the Virginia Condominium Act. Virginia Condominium Act has to be there in order for you to have a condominium. That's not the case in clusters or property owners association. The property owners association was a horrible afterthought. And you heard that from me. And it should never have been because by law, property owners association, homeowners association had always been a creature of common law. Restrictive covenants come to us from our brethren across the seas in England that basically created these things for various and sundry reasons. And now in our jurisdiction, we're paying the price because they are not favored in the eyes of the law. There's a great case, if you like, restrictions on homeowners associations that has to do just recently with amendments, came down on the necessity of having certain language in an amendment to meet the statutory requirements, which should never have been around and shouldn't be around now, but for the fact that the legislature back in 1989 decided they wanted a POA Act. No need for it. Didn't exist before. We had lots of community associations, property owners associations before that date, but all of a sudden we got that POA Act and they've not let it alone since that time. They are constantly carving away at the authority of boards and are constantly stopping things that shouldn't be stopped, in my opinion. But that's beside the point.
Okay, so if the bylaws state nothing about a certain topic, for instance, it didn't exist in 1974 and now does, like a portable moving unit, can we make a rule and regulation about how to handle it?
Great question. What's the answer? Everybody hear it?
We have a couple of questions over here.
All right, we'll get to it. Let me finish because this is real. All right, the question was, we now have a new issue that's developed in our communities, which are those pods, those things that come into our parking lot, stay for 3 or 6 months, sometimes a year, and then disappear at some point down the road. Can the board of directors make rules and regulations with regard to those pods?
Yes.
Yeah, I don't know.
It depends. It depends on whether there's authority first. Remember, go back to your recorded documents. Is there authority in your recorded documents that says the board of directors has the ability to make rules and regulations governing the use of the common area parking areas? If that's the case, you're golden. And yes, you can.
Okay.
Now, the practical problem that you're going to have is finding a tow company to tow it out of the parking lot. But they're there and they will do it, and it has been done. The other way to deal with that is also, once again, to sue in court and get an injunction mandating that an individual get that pod removed. What happens if a person has an injunction issued against him and he doesn't do that which the court has required?
Goes to jail.
He's in contempt of court, and one of the options is to be thrown in jail. And that has happened before in community associations.
If you have the authority to fine, you should do that.
Michael, you had to bring it up, didn't you? Assessment of charges. First of all, in the Commonwealth of Virginia, Michael, you should know this. We're very couth and very savoir-faire. We don't fine in Virginia. We assess charges. And there's a case to that point. It's the Build America case back in the 80s, which basically led to the ability to assess charges because the community association had adopted without statutory authority, didn't need it before. Why they need it now, don't know, but they had adopted a fee schedule for violations. And so what happened was then the Virginia Assembly said, oh, we can't have this. Let's give them some administrative authority, and we'll adopt the statute, which says the board of directors has the authority to adopt reasonable rules and regulations that relate. So everybody thought, hey, okay, so now the board has that authority. Then the Shadowwood case comes and changes the whole nature of the beast. So if you're going to have that authority, it's got to be where? In your recorded documents. So be careful of that.
There's one question back here.
Oh, I'm sorry. You had a couple. I'm sorry.
So if you want to establish rules and regulations that allow the board to assess charges, then in the case of clusters, most of us anyway, you would be looking at either the deed or the plat or the articles of incorporation.
Not in the articles of incorporation.
No.
Nope. I mean, you can try. Look at the Lake or the Arrowwood line of cases from middle of Virginia, and they tried anything and everything they could to get that finding authority and others in their documents. In fact, eventually what the court did was said, hey, you know what? We decided the Virginia Property Owners Association Act is not even applicable to you. Oh, that's a novel thought. What do you mean the Virginia Property Owners Association Act might not be applicable? Two things that are requirements in order for the Virginia Condominium or Virginia Property Owners Association Act to be applicable. And there are associations out there that do not comport with these requirements. One is that you own common area, and two, that you have assessment authority to maintain that common area and have that obligation to maintain it. And there are some associations that don't have that kind of language.
Okay.
And they're not subject to the Virginia Property Owners Association Act. Glory Day. So what does that mean?
Yeah.
What it means is we revert to the common law. So everything is based on common law, and we avoid the whole idea of the statute. So that's where you end up.
I don't understand the answer to charge.
You wouldn't, all right, here's a good example. Under the Virginia Property Owners Association Act, and we talked about this earlier,
right,
you're required to give what to a seller who wants to sell their lot?
Disclosure.
If you're not subject to the act, do you have that requirement?
Okay.
No.
Now, if in your rules and regulations, you have requirements that would encumber, I hate to use that word, financially the board or the cluster, does the board have the right to take action and recover the cost of that action if it doesn't meet, if the property owner himself doesn't meet the regulation? So if, let's say you go after somebody through an injunctive relief. Got a junk car in your parking spot. That's an easy one. You don't move it for 6 months. It's rusted. They sent notices. You still don't move it. It's your spot, okay? But the rules and regulations in your disclosure documents, where you adopted and voted on, said, yep, no junk cars, and they tow it. Could they recover the cost of the tow?
The association.
The association, because it didn't meet the rules and regulations.
The answer is probably yes.
So they can't fine I use the word profit, and I'm saying it for a reason, because there's people that let their yards and other things go to you know where, and it brings the value down. That's what part of the reason of an HOA is to maintain property values. So if we get somebody to cut the grass and charge them for it, and it's part of the rules, the grass cut.
It's gonna be dependent upon what the authority is that got you to where you want to go.
It's not in our articles of incorporation, and we don't have any CCRs.
Right, and you'd really have to look and see under Article 7 of the Reston deed what kind of authority is there for clusters associations to take advantage of. But generally speaking, there's some language in many documents that says if a homeowner causes damage or injury or cost to the association, then they're going to be responsible for that, and you might have something like that. So it depends, once again, on the documents.
Okay, thank you.
All right, let's go back.
We have a question here.
Sorry.
Oh, let me go here first and then you.
How long would it take you to define what a CCR is?
Covenants, conditions, and restrictions, CC&R. Oftentimes you'll see covenants, conditions, and restrictions, and easements. And what that is a restriction of the use against the property that's been recorded against the property. Reston deed is a fine example. There are restrictions on what you can do with your property that are set forth in the Reston deed. So anything that is recorded like that restricts the use or other, okay? Article 7, this is where a lot of the clusters do have. Oh, I'm sorry. You're getting carried away. I'm on a roll.
If a member causes you to have to get legal advice and therefore incur fees for legal services, and you assess just that one home for those fees.
I mean, you could try. You could try. But the reality is that whether you like it or not, community associations are existent. They're small businesses, and they need legal advice. Because unfortunately, what does the legislature do every year? They change the law. And you guys need to keep up with it, need to know what's out there, and you need practical expert advice. Whether it's an accountant, whether it's an attorney, whether it's your insurance agent, all those people are providing services to community associations. And they're not doing it for free. And the reality is you need that because you have certain parameters and scopes of authority that you need to comply with. You have certain requirements and obligations you need to comply with. So because you had to go out and ask an attorney, that's not going to get you to where that member is going to be responsible for those attorney's fees.
Even if they file a complaint that resulted in needing that exact advice. So it goes to special assessment to the whole community.
So when you say file a complaint, file a legal action?
Ombudsman.
Well, you're never going to restrict a member from going to the Ombudsman.
I didn't say I wanted to restrict them.
Well, yeah, you did, because you want to have a chilling effect through the imposition of attorney's fees against that member who brought you in front of the Ombudsperson.
So it goes to special assessment for the whole community. If your budget doesn't allow that much legal fees, if you have money in your legal fees line and you don't have enough money to pay,
you're going to have to change the budget.
Emergency.
You're going to have to change the budget.
It's the end of the year. It's the end of the year.
Well, then you start next year as well. And you may have to go with a special assessment. And there's authority under the Reston deed for clusters to do that kind of thing.
Right, that's what I said. So it goes to special assessment for the whole community. The board still decides it goes to everybody for that cost.
Yep, nobody said this was going to be free in terms of leading a community association. It is what it is. And you're too young to remember that old Doris Day song.
Change the rocker off.
There you go. So Article 7 and the rest of the deed is where you can get a lot of this stuff. It deals with assessments and lien authority, party walls and fences. That's a fun one. We can spend a whole night on that. Assignment of parking garages and storage. That's also there. That's actually kind of neat language that you may want to look at. Indemnification and insurance requirements, and a separate disclosure packet for every cluster association. There is also another section that you may or may not know about in the Reston deed that says enforcement of the Reston deed and any of its applicable terms, conditions, and restrictions can be done by the cluster association. Enforcement, not use of those provisions necessarily, but enforcement of those restrictions, especially as they relate to use restrictions and or architectural controls.
So use and maintenance standards?
Can be enforced by the cluster associations. Go to Article 9. I'm sure that you all keep the Reston deed next to your bedside, so if you have trouble sleeping, you can read through them. But look at Article 9. I got a question.
Yeah, so I want to make sure I understand what you're telling us here.
Yes.
All right, you said...
Because I've been clear as mud, is it?
Yeah, well, I think you have. I just want to make sure I understand. You said that any authority we get to do anything needs to come from the recorded documents. Now you're telling us
that there are some, has some authority,
a recorded document
that has some authority that relates to cluster associations, and it's specific in Article 7 to that. But Article 9 is also one that allows for a cluster association to enforce.
Explain how enforcement happens.
The answer is yes. You take somebody to court, or you have some other sort of administrative authority. Right. Cluster association independent authority, aside from the Reston deed. Once again, you're looking at all those documents we've talked about: the deed of subdivision, the declaration of covenants, conditions, and restrictions, the plats, articles of incorporation, and bylaws to a lesser extent. Since there are no condominium associations, I'm not going to go through condominium association, RA in relationship with cluster and condominium association. Realize that both a cluster and a condominium association are independent, standalone organizations. That's how they were created. That's what they are. Whether you're incorporated or not, if you've lost your corporate status, you're an unincorporated association under the laws of the Commonwealth. So be aware of that. Reston Association can enforce the provisions of the Reston deed, but as we just stated, so can cluster associations, condominium associations within Reston, and who else? Individual members of the association have every right to enforce the covenants. Reston Association cannot, however, enforce independent provisions of a cluster or condominium association's documents. That's up to you to do.
What about cluster standards?
Cluster standards are part and are designed with respect to the DRB being able to enforce that stuff. But that's within the DRB section of the Reston deed. It's not. Those are guidelines that are adopted.
It's an exception.
Right. Correct. All right. Real quickly, and then I'll just open it up to questions. There have been a number of rulings, and actually my friend over there who remembers Doris Day.
Been there, done that.
I have been to the Ombudsman. I will tell you that we are very fortunate to have the Ombudsman we do have. Heather Gillespie is probably the most reasonable and rational person we could have hoped for. She understands that there are individuals within associations who have nothing better to do than to complain. She also realizes let me ask you this, what's the scope of authority of the ombudsperson?
What's the state regulation?
She enforces the state laws, which mean what? Condominium Act, Property Owners Association Act, and the regulations. Here's a trick question. Can she enforce the Non-Stock Corporation Act? No, she cannot, and she does not. There's a ruling that came out saying what was requested from the complainant was something that was found in the Non-Stock Corporation Act. She has no authority to adjudicate those decisions having to be under the Non-Stock Act, therefore she would render no opinion. What does she adjudicate? She adjudicates final adverse decisions from the board of directors. I had a case where she determined that no final adverse decision had ever been rendered by the association, and therefore dismissed the complaint. So realize it's got to be a final adverse decision by the board to the request or information that related to the complaint. A couple other things. We've talked about jurisdiction, final adverse decisions, conflicts with laws or regulations that are related to communities. She does not interpret, or the Ombudsman does not interpret Virginia Non-Stock Corporation Act, condominium instruments, or any governing documents. That's outside the scope of her authority. And when you are responding to these types of things, you want as broad a brush in terms of the response, if you're asked for one, as possible, because you want to throw in everything that relates to anything that might be found in the condominium or cluster documents, the plats, the plans, whatever. You might want to throw in stuff like that relates to the Non-Stock Corporation Act. Access to books and records. What are some of the requirements for access to books and records? What's proper purpose?
Anything.
The answer is in large part anything. There's a decision that came down that said that a member's right to review can be done for such things as for the education of the homeowner. That was the proper purpose. And it was a proper purpose because they're a member of the association. They have every right to see how the association is being run. And when you are asked for association documents, give them up, unless they're protected some other way. This situation that just came down, the woman was also in litigation with the association. So there was it's out of Kingsmill, which is a very large association down in Williamsburg. And the attorney tried to keep the homeowner away from stuff that any other homeowner would have been entitled to, but for the fact that she felt that the proper purpose was not there. The reality is the access to documents is important. It's there to give education to the members and to let them know what's going on as to what's going on in the association. However, is it the responsibility of an association to respond to every inquiry and request that they get from a member? The answer is no. And she's come out with a decision that says no. They're entitled to access to documents. They're not entitled to you spending the time, energy, or effort to give individual answers to individual members. So you give up the documents that they're requesting, and they're the ones that have the responsibility to go through them and make determinations. One other thing, and then I'll get to your question. One other thing to be careful of in terms of access to documents is that when you're dealing with those documents, you never let them out of your sight. You always have a representative of the association there, whether it's a board member, an officer, a management company, an attorney, whatever, because there have been times when original documents have gone missing to the benefit of the person seeking access. So be really, really careful about that. Question?
Yes. Cluster documents. We have a phone list that we put out. The board uses email to send meeting minutes out to people that want them. Is the contact information of the individual members considered part of the cluster association documents? And can the member look at that information?
Great question. A great decision came out of, I want to say, somewhere out west, Oregon or Utah or someplace like that. In that case, and we think the same would be true here, there is no requirement to give email address or phone numbers of members to individuals requesting the membership list. The membership list consists of the name and the address, and that's what they're entitled to.
Okay.
Are you talking about within the cluster?
Right. As opposed to where? The free world.
Could the cluster amend the bylaws to allow that to happen if all the members? Agreed.
Well, first of all, anytime you get into the issue of email, and use of email, there always has to be consent from the individual whose email is going to be used. And across the board.
Same thing with phone numbers?
That's not as clear, but with regard to those things, they're not entitled to them.
Okay, so consent is consent, okay.
They're not entitled to it. They're entitled to the mailing list, the membership list, and the address of record that the association has, but that's it.
Isn't it there's a Federal Communications Act?
There are lots of them.
Well, basically, there's one that basically, you can't do email unless,
Yeah, and there are state laws as well that relate to the use of email. And in fact, there's part of the Virginia Property Owners Association Act and the Condemnation Act have requirements about consent and stuff. So realize that you can't use it unless you've gotten the consent. Can't use it for notice requirements unless it's consented to by the owner. So anything that has any type of restriction like that, members aren't entitled to that at all unless...
Oh, that's why I asked.
Yeah.
No.
So in other words, if you send out minutes by email, then all the email addresses should be blind copy, basically.
Right, they are, ours are. Yes.
I would suggest...
Why not just post the minutes somewhere?
They do as well. They do both.
Let's see what I got, and then I'll... Not that I haven't opened it up to questions already. This was an interesting one. There was, under the Act, there's that requirement that the association provide a means of communication amongst members. And in that case, the association said, we do. We provide a board on our website that's password protected. The individual complained about it because they indicated that it wasn't working and never did work and it was impossible to get to and they couldn't post things on the website board. And this goes once again to jurisdiction. She said, the Ombudsman said, thank you, but I have to take the board at its word because I don't have a member password. And if they say there is something there, then there is something there, and you should use that unless you can prove otherwise. So realize that even member password protected website boards may get you out of trouble. Oh, and posting of notices. We're talking about posting of notices. There was a complaint that was made by a homeowner, said the board, and this actually goes to your earlier question, said that the board met at all sorts of different times of each month, that they never could get together because they were always away, business trips, whatever, meet late night or whatever the story was. But the board consistently, as soon as they knew when their meeting was and sent notice to the board, they posted it at the clubhouse, they posted it another place within the association, and they put it on the website. And the Ombudsman in that situation said, that's totally appropriate and totally within the bounds. Not only did they do it once, but they did it at 3 different places so members could know when the board meetings were. Important consideration for all of you is to whether or not you adopt a rule or regulation saying affirmatively that when the board is going to have the meeting, the notice will be posted here, here, and here, and then follow through on that. Because then that gives the members the ability to say, oh, look, the board has acted reasonably under the circumstances. They've given notice of where the notice of meetings will be placed. We ought to be paying more attention. And you also don't have a problem then subsequently going back and saying, well, we don't know what our notice standards were. No, we've already established them. Here they are, and we do this consistently.
Or you could say meetings are typically unless otherwise announced.
You can do that too, but in this situation, in the case, they met every other month for different days each month, so it was never really consistent in nature. Okay, I'm going to open it up to questions.
I keep coming back to the Shadowwood case, and
don't we all?
So if we can't assess any charges for violation of cluster rules, what is the point of us conducting inspections other than to hope that it'll lead to the goodwill of people being told that they are out of compliance? Why not, for whoever the Reston reps are here, just ask Reston to come in and inspect for violations of the Reston standards and do whatever Reston needs?
And in Reston, that's a unique authority that the DRB has with regard to some of that stuff. So there's the help in terms of either things being not properly maintained and or that additions, alterations, or improvements have been made that are in violation. Those things should be reported in writing to the DRB and or the Covenants Committee.
But didn't you say, I'm sorry, didn't you say earlier that in Article 7 or 9, I wasn't sure which one, that the clusters have the implied authority of enforcement?
Enforce doesn't mean assess charges.
The right does according to suit.
Yeah.
Giving notices on things enforcement.
Book in the ointment, the maintenance of improvement. It says, it's on page 39 of this book.
Okay.
It says that a failure, in the opinion of the board of directors or the designated committee.
Okay.
So before you sue, you better be sure that the RA board or the designated committee agrees that it's detrimental.
Right.
Because otherwise, it isn't a violation yet.
I understand.
I will not comment on that.
How to change it if we, I mean, I know it's hard, but what is required to change it so we can charge, assess fees?
Nowadays, if you want to change that, you're going to have to go to some recorded document that affects all of the properties within the cluster and change it in that document. And it usually is an amendment. It usually is there's usually, if you have CC&Rs, it's going to be a supermajority, more than likely, 2/3 or better of the members to get to that point. But that's the only methodology that you've got right now under the Shadowwood line of cases.
Okay, and can a supermajority be met by online voting or voting by mail?
The answer is, it depends upon what the provision on amendment says in your documents. The case that I referenced earlier is there was an amendment case that came down just recently, and it didn't have the language that's required by the statute in the POA that talks about the certification of the requisite number of votes or consents necessary. And because of that, an amendment in 2008 was deemed by the Virginia Supreme Court, despite the fact that the Circuit Court had no problem with it. The Virginia Supreme Court ruled that the 2008 amendment was ineffective in 2015. Now remember, under the POA and under the Condo Act, there's a provision that talks about a 1-year time frame within which to challenge. But the court here said that the challenge did not matter because the amendment itself from ab initio was defective. So realize that part of the reason here too is that the amendment dealt with leasing. And we talked, Michael and I talked a little bit earlier about the issue of the savoir-faire and, debonair nature of the Commonwealth of Virginia. One of the things that's sacrosanct in the Commonwealth of Virginia is real property. The covenants that we have, this is an abomination to many of the practitioners on the bench, and they are viewed very restrictively and are interpreted strictly. So what you need to be aware of in this case, it was a restriction on leasing that had been amended in 2008, and they found a way to get the amendment kicked. So if you're dealing with stuff that has to do with real property, be careful. It can be done. We have another situation. We didn't do the case before the Supreme Court, but we have another case where we amended documents that restricted leasing of units, and the court in that case found us totally within the bounds because we had amended properly and had the language. I thank you for your attendance tonight. Appreciate you being here. A lot of good questions. I hope you can deal with my sense of humor. I like to bring it from time to time, but I appreciate you being here, and thanks for coming.